Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. This court, from recess, now sitting.
Thank you. Please be seated. Prepare to hear 15 minutes of rebuttal that was reserved.
May it please the court, I just have a few quick points that I would like to make. First, I know I didn't talk at all about the Ann Walenta case. I would note the state is relying on a harmless error kind of analysis to her confrontation clause statements based on the idea that we missed an objection. I would note that defense counsel had made multiple objections prior to that point and had been granted continuing objections to any hearsay statements from Ann Walenta. And that's in volume 102 at pages 39 and at pages 55 and 56. There comes a point where once you have a continuing objection, you've made it known to the court that you object to this testimony coming in. The district court has said, I understand your objection, I'm letting it in, you have a continuing objection. How many more objections do we need to make?
Was there a confrontation clause objection, or were those just hearsay objections?
I recall them on the record, like at the trial, as being made as hearsay objections. I would point out that this was pre-Crawford,
Yes.
so they were in a different confrontation clause world than we recognize today. And I would certainly suggest that this court, both under the doctrine that if you're on appeal when a new case comes out, that you can apply that case. And so since we didn't have the framework of testimonial versus non-testimonial, we didn't have any of that understanding at the time of this trial, that we can still apply the Crawford analysis to the Ann Walenta statements. And of course, the specific Kansas statute that authorizes this court to look at unobjected to issues for the first time on appeal.
Would you address your opponent's argument that that only applies to those counts that are death eligible, which wouldn't apply in this case?
I think it's problematic to parse through a trial of this magnitude, which specific evidence goes to only the capital murder cases, which specific evidence might be brought forward at the capital trial. The purpose of that statutory rule is to codify, if you will, the Eighth Amendment reliability requirements that go into a death sentence. And to me, everything that happens then at a death penalty trial, especially one that results in capital murder convictions and a death sentence, we have that problem of, did this in some way factor into any part of the capital murder decision? Did it factor at all into the death sentence decision? I think it's problematic to say we're going to parse out which parts of the trial get that extra scrutiny and which parts don't, when the entire trial results in a capital murder conviction and a death sentence. That would be my answer to that, that everything factors in.
We can look it up, but as it pertains, you said there were continuing objections, and I think that was to the officer's testimony regarding out-of-court statements. But what about, was there an objection to the husband's testimony, Don Walenta's?
No, the first objection that was made was to Anna Kelly, and that's at page 39 of volume 102, and that was a continuing objection. Next comes Officer Joshua Lewis.
And there was an objection
50,
there.
And it was a continuing objection to any hearsay statements of Ann Walenta. So certainly the purpose of the contemporaneous objection rule, which is to give the district court the opportunity to reconsider the issue, the district court had that opportunity. The district court clearly made its ruling that Ann Walenta's hearsay statements can come in. We made multiple objections. We were granted continuing objections to Ann Walenta's hearsay statements. My argument then is that that is sufficient for the contemporaneous objection rule. I would like to return with my last few minutes to the remedy for the Batson issue. I continue to be troubled by the suggestion that the remedy can be exclusive to the penalty phase simply because of the explanation that we gave for why we didn't want this particular juror on the jury. Certainly Beck v. Alabama cautions us not to stop only at looking at what goes into the penalty decision, but says that the reliability requirements of the Eighth Amendment take into consideration what happened at the guilt phase trial. That is part of how we know that we have a reliable Eighth Amendment ruling, a reliable death sentence, a conviction, and a death sentence that we can feel comfortable with comporting with the Eighth Amendment. If we parse out a remedy to a jury selection issue and say that really only affects a penalty because you said you really only worried about how this guy viewed the death penalty, that troubles me. We're not properly remedying that problem, which is that Jonathan Carr was made to sit and be judged by this individual that he wanted to strike from the jury, was entitled to strike from the jury, and was erroneously disallowed from striking from the jury. The remedy has to go to the entire error and not just to the penalty phase. That would be our argument. In summation, I would respectfully request that Jonathan Carr's convictions and, of course, his sentence be reversed and that he be remanded for a new trial, separate and apart from his brother Reginald.
Do we have any further questions of counsel? And I see no further presentation.
No.
All right, thank you, counsel.
Thank you.
Thank all counsel for your arguments this afternoon. Court will take this matter under advisement. At this time, court is adjourned.